Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a subject that most of you probably don't know nearly enough about: evidence. Stay tuned. A lot of times I see questions on Quora and other places about how do I get a document admitted into court, or how can I use a document in court? How can I use a photograph in court? And the answer to these questions is not as simple as it seems. You don't just walk up to the judge and hand them the photo and say, "See, this is what my tenant did to my house." It doesn't work that way. One of the problems that you face when you are a pro se litigant is that if you do not understand the rules of evidence, then it's going to be very, very difficult for you to get evidence admitted into court. Now, I want to set aside for a moment small claims court, because the rules of evidence usually don't apply in small claims court. And indeed, in small claims court, you can walk up and hand the judge the invoice from the plumber and say, "Yes, this is what it cost me to get my plumbing repaired after my tenant was in there." But that is a different set of circumstances because you're suing under a different statute and a different set of court rules. If you are in a regular courtroom where the other guy is represented by a lawyer, you are at a significant disadvantage if you are not represented by a lawyer. Now, several years ago, I was asked by the Samaritan Center Project in Jefferson City to represent a woman who had been, they were trying to evict her from her house. And they hadn't followed all of the statutory requirements, and I went in and made that argument. And the other side tried to get in a bunch of evidence about missed payments and that sort of thing, prior missed payments that he hadn't taken any action on. And I made the proper evidentiary objections. He would hold up a document and say, these are the missed payments. And I would object on the basis of foundation. Foundation basically means you have to show how that document is, what its provenance is, how it came to be. So, for example, if you're trying to admit something that is a business record of yours, a series of rent receipts that you keep in a book, you have to come in and say that this is a business record and you are trying to admit it under the business record exception to the hearsay rule, because what's written in a document is hearsay. It is material that you would like to have the judge consider as proof, but you're relying on the contents of the document as proof. So in order to get it in, it has to be subject to a hearsay exception. And if you don't know what the hearsay exception is, you're going to have a hard time getting that particular document in. That's why, even if you have a relatively small case, if it is important to you, for example, getting a bad tenant out of your property, if that's important to you, then you probably need to hire an attorney to make sure the job gets done. Because all an attorney would have done would have been put the witness on the stand and ask a few simple questions, and he would have gotten that document right in. I don't know that it would change the result, but the guy wouldn't have been frustrated by the fact that I used procedure against him. Now, it probably seems unfair that a lawyer would use procedure against somebody. Why don't we just try the case on what we know? Well, the problem with that is that a lot of times what people know and what people testify to is not the actual truth. It's some mix of truth and falsity and self-interest. And you have to realize that a lot of things that people believe and know are subjective. They're not objective. It's not 2 plus 2. It's what do you want 2 plus 2 to be? So You have to think about that when you're dealing with evidentiary issues. And most people, if you haven't been through law school, if you haven't taken a course in evidence, if you haven't tried to get something admitted in court and failed, and hey, guess what? That'd be me. I've certainly failed to get documents admitted into court because I didn't lay the proper foundation for them. So let me just explain to this again. If you have things that you need to get in front of a judge, for example, a photograph that you took, you can testify to. I took this photograph and it shows what my house looked like on the day that the tenant left. Okay? And it's accurate and it represents what I actually saw. Those are the things that you have to say in order to lay a proper foundation and have that document admitted. And even then you might still get an objection, but the problem is that it will probably be overruled if you lay a proper foundation for that photograph. But if you don't know enough to do that, then you're going to have a problem. So if it's important to get things into the courtroom and to get it in front of the judge or the jury, you really need to have a lawyer to help you to do that. I can't emphasize it enough. It isn't a matter of us as lawyers trying to generate fees. I have represented a lot of people for absolutely no money whatsoever because I thought it was the right thing to do. And I know a lot of other lawyers have done exactly the same thing. Robert Barnes, for example, very famous lawyer. And he's out there representing people pro bono sometimes because he believes in what they're doing or what they represent. So you have to understand that lawyers as a group of people are not always necessarily trying to get a big fee. And don't forget, if you have a small case and you just want to get a couple of pieces of evidence into court, you can hire an attorney and negotiate a fee with them. Look, I just need you for a few minutes. Can you charge me $100 to come and do this? And then if he charges you $100 and the statute permits it, you can recover your attorney's fees. Some states have statutes that allow you to recover attorney's fees. That's a win-win situation for you. You not only get good help, but you get paid back in the end if you win, which again is a good deal. But again, you have to know whether or not your claim is worthwhile, and that's probably also something you need a little bit of legal advice for. I don't want to go too deeply into this, but I do think it is appropriate to caution people that when you approach a court, you have to show respect, and part of showing respect is knowing how things work. So if, in spite of this, you decide that you want to take this on and try and get your evidence in without a lawyer, do yourself a favor. Go to court and watch 2 or 3 trials before you do this. Because if you do, you will get a flavor for how these things are done. Take good notes, and that will help you. But even if you do that, you still could wind up with a irascible lawyer on the other side who uses procedure against you, and I just want to prepare you for that because that is quite likely. So, hopefully you found this interesting or helpful or good information, if nothing else. If you have, I'd appreciate a thumbs up and a like on this video. And if you haven't already, go over here and subscribe to our channel and tap on the notification bell so that you can be notified anytime we release a video. If you have comments or additional questions or have a topic that you would like to have expressed here on this channel, a question perhaps, a legal question that you want some information about, I can't, unless you're a Missouri person, I can't offer legal advice because I'm licensed only in Missouri, but I'm happy to talk about the subject generally as I do here without providing legal advice. The only way I provide legal advice is subject to a contract to represent you. So, in that regard, I want to make plain this is not legal advice. This is just professional caution sort of being urged here for people who want to represent themselves. It's a steep hill and a difficult hill to climb. Thank you so much for watching. Have a terrific day, and I'll catch you on here next time.